Well, I got an interesting letter/email this morning from HNK informing me that the judge hearing a case has ordered me to pay £4,000 to the Metropolitan Police for legal fees by the 21st of March. Hi guys, welcome back to the channel, welcome to the channel if it is your first time around here.
Hi guys, welcome back to the channel, welcome to the channel if it's your first time around here.
Stop it. Get some help.
Yes, I suppose you're right, Michael. I do need to stop it and get some help. It's Marty again. Now, we all know Marty is a born winner. He can't stop winning. Just ignore all the haters and the negative people. Marty is a winner.
Well, I got an interesting letter/email this morning from HNK informing me that the judge hearing a case has ordered me to pay £4,000 to the Metropolitan Police for legal fees by the 21st of March.
Wait, what was that?
That the judge hearing a case has ordered me to pay £4,000 to the Metropolitan Police for legal fees by the 21st of March.
That can't be right, can it? Not Marty. He's a winner. We better play that back.
That the judge hearing a case has ordered me to pay £4,000 to the Metropolitan Police for legal fees by the 21st of March.
It must be a setup. It can't be that Marty has lost out in a court case. He's an expert in the law.
Right, bloody hell, it's a bit... Yeah, you know, bloody hell, but yeah, so...
Yeah, it is a bit bloody hell, innit?
Start buying this merch, guys. Marty B needs the coin. Link is in the description below.
That's right, and don't think we're letting you lot off the hook either. I want all my subscribers to help Marty out of this financial hole. He's £4,000 down, so come on, get your checkbooks out.
It's Christmas time. There's no need to be afraid.
I say, steady on that chap. I don't think things are going to get that bad for Marty. I mean, 4,000 notes is a lot of money, so if you can help Marty out, then please do so. But I do think we should look into this further and see if we can figure out what has been going on here.
So yeah, right, so let me give this breakdown. So many of you will probably remember, hang on a minute, this video.
And here's what Marty and his friends got up to in that video.
Idiot.
Wayne Cousins lookalike, isn't he?
Sorry?
I said you idiot.
Right.
But long story short, without doing an audit, a Catford police base in London, and officer went hands-on with us when we was in a publicly accessible place. I called him an idiot. He arrested me for calling him an idiot under, so I think it was section 5, public order, and gave me an on-the-spot £80 fine and let me go. Anyway, obviously I challenged that fine.
Marty is perfectly entitled to challenge such fines, but my initial thought about this is that if you're going to call a police officer, or really anybody, an idiot or a Wayne Cousins lookalike, then you need to have a pretty good reason. It's not like you're a little kid, Marty. If Marty was a 7-year-old kid, then calling somebody an idiot because he doesn't like them or they've done something to displease him might be expected on the basis that a 7-year-old kid is a 7-year-old kid. But Marty isn't 7 years old. I know he acts like a 7-year-old, but he isn't. He's a married man in his 30s. So for him to call anybody an idiot, never mind a policeman, does need a fair justification, otherwise it just looks like childish behaviour and it can be dismissed as such, and Marty should hardly be surprised if the policeman takes umbrage and goes as far as locking him up. Putting aside the legalities of it, we won't be going into the original incident for reasons I will explain in moments, but putting aside the legalities, if you're a grown adult and call someone an idiot, what do you expect to happen? I'm surprised Marti is surprised. I mean, if the policeman had been at Marti's own home and not had a proper reason for being there, I could understand it if Marti started calling him an idiot, because we must remember that Marti is only human like you and I, and a normal, well-balanced, responsible individual may call even a policeman an idiot in certain exceptional circumstances. But these were not exceptional circumstances. This was a situation where, as usual, Marti and his friends had turned up somewhere to cause trouble.
I beat it, they cancelled the fine, and now I am currently suing the Metropolitan Police for unlawful arrest, etc., etc.
Marti is a very litigious individual, isn't he? He keeps these solicitors busy. Isn't it funny, and doesn't it strike you as odd, how Marti keeps having all these legal problems? It's almost as if he's being targeted. I'm getting worried for you, Marti.
During the ongoing court case, the Metropolitan Police requested a court hearing to obtain a court order to force myself to divulge the following information. Number one, how many views on the claimant's YouTube channel for the videos about him. Two, when the photograph of PC Woolston was uploaded, when it was taken down, what footage of the incident still remains online, how and on what basis I earn or generate income on my YouTube channel. I'll put this there as I'm saying it, so you can see it yourself. What money I have earned from said videos about PC Woolston, any documents relating to said revenues, documentation from YouTube or any other records of incomes, copies of bank statements and copies of accounts and or tax returns. Like, who the bloody hell do they think they are? I mean, the reason that they're asking for this information, because they want to argue that, he's already earned money off it, so basically he's not entitled to damages, which is absolutely ridiculous. It doesn't matter if I've earned money off of the content or not. It's irrelevant, isn't it? It's completely irrelevant.
Is it? Well, clearly the judge disagrees with you, Marti. Before we go any further, one thing to note is that this is an ongoing case in the civil courts. Therefore, it is sub judice. So normally I wouldn't make any comment at all due to the operation of contempt of court rules. Any detailed comment on the case itself, where that case is active, could be construed as an attempt to interfere with or prejudice the proceedings. Of course, any comment I make here about this particular part of the proceedings involving the issue of whether Marti should make the disclosure and whether he should pay the £4,000 costs is unlikely to be sub judice, because the matter has already been decided and so is treated as res judicata. Nevertheless, there is a risk of falling between two stools and into contempt when commenting on the wider claim being brought by Marti. Our guide in this regard is paragraph 12 of Schedule 1 to the Contempt of Court Act 1981, which defines an active civil proceeding as any proceeding that is heard in a civil case, and we can infer from what Marti has said so far that there has been at least one hearing in the case, and even if dates for further hearings have not yet been fixed for the case and the projected trial date he gives later in this video is just an estimate from the court, I'm not taking any chances, so I certainly won't be reviewing the original incident at the moment. I may do so when the case is concluded, but not now. If you want to watch it for yourself, a link can be found in the video description. We do need to be careful what we say about it at this point because, as I say, it is sub judice, and in any case we don't have access to all the court submissions by the parties to the litigation, so we don't know what the exact reasons are for the Metropolitan Police to ask him all those questions. Aside from the law of contempt, another consideration floating around in my head is that there are some points I could make that would probably assist Marti or his solicitors, and I would rather not. At this point, I would simply make the observation that if the judge has decided that the information should be disclosed because it's relevant, then it should be disclosed because it must be relevant to the determination of either liability or quantum being the amount of damages the police should pay to Marti Blagborough if he eventually wins the case. Quite apart from that, these questions from the lawyers acting for the Metropolitan Police seem fairly innocuous to me, or would be for someone who is not trying to hide his income. Why would Marti Blagborough not want to answer questions about his income and how he earns money from his online activities? As matters stand, not only has Marti now got to disclose all this documentation and information, he also now has to pay the costs of the lawyers acting for the Metropolitan Police, because they had to force the issue and take the matter back to court, and their costs are £4,000, as Marti says. If Marti had simply provided the information in the first place, he would not have had to pay £4,000 at this point.
But anyway, that's what they're arguing. I mean, I've hardly earned out of them videos.
Well, here's a video, and you'll see here that it has so far had 37,000 viewers over about 3 years, which means his earnings from it in total are probably about £40 to £50. But it has earned something significant for him, a £4,000 invoice.
I mean, was it like 2022 or... I think it was like late 22, I can't really remember, 22 or 23, whatever. And I was only a little channel then. I only had about, I don't know, I must have been on about 20,000 subs or something like that. But I had a look and I only made like 50 odd quid on one and whatever that says for the other one, I can't remember. But it wasn't a lot, and that's over them years as well, you know what I mean? Pennies really. Yeah, so basically we contested this court order getting granted, and the judge awarded it. It was Judge, I can't even pronounce this name. Hang on, I'll get AI to read it out. The name is...
Judge Changizi.
That one. I probably couldn't pronounce it even if I tried, so yeah, we'll do that.
No, I don't think you could pronounce it. My only fear about making this video is that it may get me into trouble with Marti's prestige solicitors, Kowts and Kway.
This is Q2, Whitehall Kway. Kowts? That Kowts bank cancelled Nigel Farage.
But you know me, I soldier on. I can take the hits. I've got broad shoulders.
Exactly £4,000 as well. Exactly £4,000.
I must admit, in all seriousness, Marti does make a good point there.
And even gave me bank details to pay them with it as well, the cheeky buggers. £4,000, you know what I mean? £4,000. Mental. Anyhow, so yeah, I'm gonna have to have some discussions with HNK. I've got a meeting booked in because I'm not happy about that. I mean,
but Marti, I thought HNK Solicitors are the top lawyers in this field. What's going on? I think you need to sort them out, Marti. Put in a complaint about these solicitors because you found yourself forking out £4,000 when you thought you were going to win compensation, and you've only earned £50 odd since 2022 from the video. It's not on. I'm right behind you on this one, Marti.
I mean, what does, like, when it was taken down and all this sort of stuff, how is it relevant? I mean, what is relevant if you're claiming that by me making money, it affects what damages I should be awarded, and all you need to know is how much money them videos earn, right? Why do you need to know all this other stuff?
All I will say at this point is that clearly if the judge has decided that you must disclose on the other points, giving details of your finances and tax returns and so on in relation to your online activity, then it must be relevant. The judge would not have ordered you to disclose unless it is relevant. But don't listen to me, Marti. You put in an appeal and tell the judge you want to overturn it. I'm sure that will go down well. I mean, it's only £4,000 and Marti always wins.
What's it matter to you how I make money on YouTube? You know,
it clearly must matter, or the judge would not be wasting time issuing court orders, Marti. Has it occurred to you, Marti, that you may not know as much about the law as you think you do?
Well, that's my bank statements. What's that got to do with you? Really, that doesn't show what video made money. It'd show the payments that I received from YouTube, but it would show the entirety, wouldn't it? Not the breakdown per video. And my accounts or tax returns. What the bloody hell has that got to do with anything? They can sniff off, mate. Think they're getting personal financial information off me. No. Not allowed.
Unfortunately for you, Marty, you've been ordered to make this disclosure. This documentation and information must be disclosed to the Metropolitan Police. It's not a choice. It's what happens in court. Each side has to disclose stuff to the other. Your lawyer should have explained all this to you at the start. But don't listen to me, Marty. What do I know? Instead, just tell the judge what you've told us.
No. Not allowed. No. Not allowed. No. Not allowed. No. Not allowed.
You see, this is what I like about you, Marty. You're an innovator. This legal strategy of telling the judge, not allowed, will definitely work. The judge will be impressed and will immediately fold, apologise, and maybe even the Metropolitan Police will offer you a settlement at that point. I think it's brilliant.
Like, it's absolutely bonkers, that, isn't it, guys? Absolutely utter bonkers.
You're bonkers.
So yeah, that's the 4,000 police at £4,000 to the Metropolitan Police.
How embarrassing. Even if it is overturned somehow, which is a distinct possibility, how embarrassing to be in that position where you sell yourself as someone who knows what he's doing and can get one over on the authorities, and yet you're the one who has to pay £4,000 to them on a video that's earned you 50 quid in 3 years. And how desperate must you be here to want to make a video advertising your own humiliation? Anybody with sense would have kept quiet.
By the 21st of March, 25. Get buying that merch, guys. Get buying that merch. Absolutely bonkers. What can you say? What can you say? It is ridiculous.
It's not ridiculous. Well, sorry, you are ridiculous, Marty. But the judge isn't being ridiculous. The judge is a paid professional, Marty. The judge has no vested interest in issuing disclosure orders and costs orders for no reason and wasting everybody's time. Here's another thing to consider. You can't accuse the judge or anybody in the court system of being biased against you, Marty. You've had your share of compensation, even though you never deserved it. Now you're getting some pushback. They're wise to you now, and while I certainly don't claim any credit at all, I think it is partly because of people like me who have shown how what you do is not legal at all, and you've effectively been scamming public bodies out of compensation. How does it feel to be scammed back?
I can also tell you that they're using this, the Metropolitan Police specifically, are using this technique not on myself but on other auditors.
What a shame. Get the violins out and pass the bucket round.
I won't say who, because he might not want to make it public, but...
That's jolly decent of you, Marty. Respecting someone's privacy. You can count on Marty to keep his word in this regard, I'm pretty sure.
Yeah, it's not only me they're trying it with.
Good. I hope they do this with all of you, and I hope other police forces copy them. And other public bodies. And, for that matter, anybody else who is victimised by people like you.
We'll see what's going on. So, in relation to that court case, the defendants, i.e. the Metropolitan Police, are set to stand trial in it's October this year for the false arrest. Well, they are standing trial, not are set, unless they deal beforehand, but by the looks of where they're playing it, there's going to be no deals here. It's all the way, you know.
I'm glad the Metropolitan Police are contesting it. It's about time they started pushing back on this nonsense. He used the phrase false arrest just then. Not that it's a big deal, it's a matter of nomenclature, but I would say that's not the best legal terminology, although I have seen lawyers and even the courts use it. I've seen the courts use the phrase both the phrases, both false arrest and false imprisonment. Of course, we don't know exactly what his claim is against the police. It could be for any one of a number of things. But people commonly use phrases such as false arrest and false imprisonment when they really mean that the arrest or imprisonment was unlawful, which I think the word unlawful better captures what it actually is, and essentially the different phrases are synonymous anyway. Sometimes you'll hear lawyers and judges use the word wrongful, which effectively means the same thing as well in this context. Claims for unlawful arrest and unlawful imprisonment often go together and involve the same facts, but technically they are distinct claims.
And just to be clear, if I lose that court case, right?
Fingers crossed.
They're going to demand off of me £60,000 in fees. £60,000.
Now, normally we'd say that would be moot or academic because he will never be able to pay and he has no assets, making him in effect judgment-proof. This is one of the paradoxes that the law produces. A poor or indigent person can actually be quite powerful in civil litigation in some situations because they have nothing to lose, and their lack of any significant assets or income means they have nothing to fear from being pursued by a successful opponent for payment of a costs order or judgment. But that doesn't apply to Marti, or at least he can't rely on it, because he does have at least one valuable asset, or should I say two. His own YouTube channel and his Facebook page earn income and are commercial assets that could be seized by the Metropolitan Police, should they win this case and or decide to enforce any order that Marti Blagborough should pay their costs. It could be plausibly argued that Marti Blagborough's YouTube channel and Facebook presence have commercial value even without Marti Blagborough, because he has a back catalogue of content that is income producing, and moreover, the Metropolitan Police may decide to seize his social media channels for their own purpose of crime prevention. By using a costs order as a means of shutting his social media channels down, that won't stop him, because he can just start another channel, of course, but it would disrupt his activities considerably, and it would make him think twice about what he's doing. That's something not just for the Metropolitan Police to think about in this case, but also for other police forces and public bodies, and also business owners who have been victimised by this man, and any of his other victims who want to bring a private prosecution or civil claim against him or any other auditor. That's why this video by Marti isn't very smart on his part.
I'm unhappy enough as it is with the £4,000 that's been awarded to him, but imagine 60 odd bags. Woo.
He doesn't understand how much trouble he's in. If I was in his position and facing a £4,000 costs order, I would be really worried. I've become fairly relaxed and blasé about the problems life throws at you, but even I can tell you that a £4,000 costs order from a county court judge will be keeping me up at night. Definitely. If I was in his shoes, I would not be making videos telling all the world about it either. I would just want it resolving as quickly and quietly as possible.
Anyway, guys, listen, that's it. There's your update. Is what it is, isn't it, mate? Is what it is, guys. So, yeah, if you want to support the channel, yeah, check the link down below in the description box and grab yourself some merch.
You heard the man. Get yourselves over there and support Marti.
It's Christmas time. There's no need to be afraid.
All right, it's not that bad. It's £4,000, not 4 million.
You know, we've got this t-shirt up for sale. Truth is just a hurt speech. And then we've also got this t-shirt, which is, I think, my personal favourite. I am not far right. I have just been right so far. Come on. It's available in all sizes from small all the way up to 5XL. So yeah, check out the description box below, guys, if you want to grab yourself some merch.
Well, there you are, Marti. I've plugged your merchandise. You can't complain, can you? Don't say I never help you out. Is this a change in the police and judiciary's attitude to auditors? Are they now finally seeing through these people? Maybe, maybe not. It's interesting that Marti did not want to disclose to the Metropolitan Police the information requested, even though he had already been ordered to by the judge, and we must assume that HNK solicitors are competent in civil litigation matters, and so they must have given him a written cost warning, telling him that by refusing to comply with the judge's order, he was risking a costs order due to the need for the Metropolitan Police to bring the matter back to court. I assume that HNK solicitors will now be telling Marti that if he wants to win the case, he must comply with the judge's orders. If he thinks he has a basis to appeal the order, it will need to be a strong reason, and he will be risking another £4,000 costs order should he decide to appeal. I suspect he's hiding his income, but that's just my speculation. Whenever legal action is brought, there is a risk of a costs order. In other words, an order from the court that you should pay the legal costs of the other party. This normally arises where you lose the case, or where, as here, the other party makes an application to the court for its costs because you failed to do something that the judge ordered you to do. This is the case even if you enter into what are colloquially known as no-win, no-fee arrangements, technically known as a conditional fee agreement or CFA, or it could be a damages-based agreement or DBA, sometimes called a contingency agreement. A CFA is often misleadingly referred to as a no-win, no-fee agreement, but it's important to understand that the no-fee only refers to your own lawyer's fees. Unless your opponent's costs are insured, you would have to pay their costs if you lose. The misunderstandings are not helped by the fact that a leading solicitor in this area of work, Kerry Underwood, entitled his book on the topic, No Win, No Fees, No Worries. Anyway, under either arrangement, HNK solicitors would have agreed to take on Marti's case without any upfront payments from him or payment of their fees and expenses as the case progressed, on the condition that they receive either an uplift in their fees if they win the case, which is what happens under a CFA and is known as a success fee, or a percentage of Marti's damages, which is what happens under a DBA. The difference is that under a CFA, the lawyer's basic fees and expenses are charged direct to the client, but the lawyer also charges a success fee, which is deducted from the client's damages, whereas under a DBA, all the lawyer's fees and expenses are deducted from the damages. In cases run under a DBA, these fees are in turn recoverable from the losing opponent, but there are caps and restrictions on this that mean the client may still have to pay a large chunk of a lawyer's costs. In cases run under a CFA, the success fee is not normally recoverable from the opponent, but the basic fees and expenses are, again subject to certain restrictions. In either arrangement, Marti is still liable for any costs orders that the Metropolitan Police may obtain during progress of the case, and would still potentially be liable for the costs of the Metropolitan Police if he loses the case. As I mentioned moments ago, there is a possibility that these cost risks can be insured under what is known as an after-the-event insurance or ATE insurance policy, so that the insurer pays the cost instead of Marti. But I would think that it is unlikely to be the case here that Marti has such a policy given the nature of his activities, unless Marti has lied to the insurer and simply represented himself as an innocent photographer. Moreover, I doubt the insurer, if there is one, will be very happy to hear that they have to stump up £4,000 because Marti, in his great legal wisdom, thought it best to ignore the judge's order. It is possible that his non-compliance could have invalidated or voided such a policy. I hope HNK solicitors advised Marti about the risks of a CFA or DBA before he signed on the dotted line, and I hope they explained to him that he still has to pay if he loses or doesn't comply with court orders. I also hope that HNK solicitors advised Marti about the risks involved in not complying with a costs order. Any unpaid costs will attract liability to pay interest thereon from the date of the order, and there will also be additional cost to Marti if the Metropolitan Police have to make further applications to court to enforce the costs against him. But the court has the power to do still more immediately serious things. The court could stay the proceedings or issue what is called a debarring order, in which case Marti's claim would not be allowed to proceed any further until those costs are paid, or he has come to some payment agreement with the Metropolitan Police, maybe. In the 2024 High Court case of Changizi and Mays and Changizi, the court stayed litigation over an estate due to a failure by one of the parties to pay costs, which was considered an abuse of process. The court could also issue what is called an unless order, which means that Marti's claim against the Metropolitan Police will be dismissed unless he pays the costs by a certain date. Persistent non-payment could also be treated as a contempt of court. Though that would seem a little harsh and rather unlikely, one must remember Marti Blagborough's response to Judge Changizi.
No, not allowed. No, not allowed. No, not allowed. No, not allowed.
I still maintain that that's a brilliant gambit on Marti's part, especially if he could manage to turn up at court with 2 pencils in his nose and a pair of underpants on his head.
A large crisis requires a large plan. Get me 2 pencils and a pair of underpants. Right, Bolrick. This is an old trick I picked up in the Sudan. We tell HQ that I've gone insane, and I will be invalided back to Blighty before you can say wobble.
The judge may not buy it, but you never know. Give it a try, Marti, is my advice. Marti will hope he never has to pay that £4,000, and perhaps he won't, but as I've explained, failure to pay, especially if it's willful, could affect his ongoing case against the Metropolitan Police. I hope the Metropolitan Police try to enforce and recover these costs. If Marti is self-employed, it will be difficult, but it can be done if he is required to attend a procedure known as an examination of means, in which he has to provide the Metropolitan Police with full information about his finances. And remember what I said earlier, his YouTube channel and Facebook page are valuable assets in their own right. One reason I don't get as excited as certain others about nailing auditors is because I think it's best to do this cleanly. Let it all unravel slowly on its own. I know they are hanging themselves and they will eventually start catching colds. A few of them, Marti included, have been sailing close to the wind for a long time, and in effect his activities only continue at the grace of the authorities. I think Marti will get away with it this time, but this is a warning shot for him. He won't heed the warning. He isn't bright enough. He'll just continue with his obnoxious campaign of arrogance and ignorance until he is actually stopped. Eventually, he will get what's coming to him.